Thank you very much. Good afternoon. My name is Tamara Nanayakkara, and I'm representing the World Intellectual Property Organization. And thank you very much to the Estonian Research Council for inviting me here. For those of you who don't know, the World Intellectual Property Organization is the foremost global forum, intergovernmental organization of some 180 countries. And we do a variety of different activities, but broadly establishing the legal norms, international legal norms in the area of intellectual property, as well as cooperation with the member states and providing support in the area of IP. So before I proceed on to IP strategy development, I would like to just take a step back and ask ourselves, what exactly are we talking about? And why are we talking about this? Why is this so important? I think many other speakers have covered these areas. I'm probably going to cover as they go along in the next 2 days, but I will just spend 2 minutes. I don't think it's lost to go back to the basics. So intellectual property basically refers to a system that provides proprietary rights over creations of the human mind. So we are referring to inventions, trade secrets, literary and artistic works, designs, symbols, names and images used in commerce. And these rights are created by law, which are variously known as patents, trademarks, geographical indications, copyrights, design rights, trade secrets. And we have this system because they serve an important policy objective. And that policy objective is to promote innovative and creative activity on the one hand, and on the other hand, to encourage fair trading and commerce. And essentially, both of those should contribute to economic progress and development. So this is the essential basis for having an intellectual property system. Now, the intellectual property rights that we have are basically a basket of different rights. They are not in watertight compartments that easily fit into one type of creativity or another. If you have an innovative product or process, they would usually, you would usually be getting a patent right for that. But you could also have a trade secret over that. Cultural and artistic works are usually protected by copyrights, but you could have other types of perhaps design rights, even trademark rights might apply to them. So there is a lot of overlap. There are blurred areas. It's not a clear-cut area, and it's a very complex area of law. But broadly, you could see a basic structure where your innovative activity would qualify for a certain type of intellectual property rights, and you would require to do certain things to acquire those rights. And the law will specify in each case as to what would apply. But the most important thing is, why is this important? Why are we talking about it? And from as I mentioned earlier, there's a policy objective to that, and that we want to contribute to economic progress and development. So I have looked at it broadly in very simplistic terms. If we talk about economic development, we are talking mostly about the industrial and service sector that is producing goods and services in an economy. That is one of the fundamental pillars. But then we have the other pillar, which many of you belong to, which is the knowledge base or the research sector. These two are very important elements in a national innovation system. And then we have various support structures that allow these two pillars to function efficiently. So we would have various mechanisms to provide funding. We have other intermediaries like science parks and incubators, innovation centers. We have IP service providers, lawyers, business support organizations, etc. All of these individuals or institutions provide support to the innovation system to function effectively. And as a society, as an innovation system, we want all of these to perform to their maximum, to have the maximum output in an economy. So where does intellectual property fit in? You have, on the one hand, IP stimulating the creation of knowledge. You have IP enabling the transfer of knowledge, and you have IP that adds value in the marketplace. So IP is a kind of a string that goes through the whole innovation system and kind of holds it together. So it's an important component. Of course, there are many components to an effective innovation system. IP is not the only thing, and certainly not the only solution, but it is one of the important aspects one has to consider in having an effective innovation system. To look at this a bit more in detail, when we talk about IP stimulating, we have to look at the context of innovation. Innovation is, as many of you know, is a very risky, time-consuming, and expensive activity. So you spend a lot of time and energy and cost in producing certain type of knowledge that might be inherently useful to society, but you have no way of preventing other people from exploiting that and using that same knowledge that you have spent so much time and energy producing. So in effect, there's very little incentive for people to actually spend that kind of time and energy producing that knowledge. But from a policy point of view, every government wants to promote that as much production of knowledge takes place in a society. We want to have knowledge being produced in a society. But if we are not able to give those knowledge producers something to hold on to, we are not able to incentivize them. So we need to provide incentives to these people to engage in the knowledge production activity. So the IP system is one of the mechanisms. Again, it's not the only mechanism, but one of the mechanisms that are there to promote the innovators amongst us to produce this kind of knowledge. Because through the IP system, they have a proprietary right over their output. And through the proprietary right, they're able to control the use of that output by third parties. And that, in effect, gives them a certain control over third-party behavior, and as such, that incentivizes them to produce knowledge. And in addition, the patent system requires, to get a patent, you have to disclose your knowledge. That's one of the conditions of the patent system. You have to disclose your knowledge, and as an earlier speaker pointed out, you use existing knowledge to create further knowledge. So you need that existing knowledge to keep building on that. So we need, again, as a policy objective, you need to disseminate the knowledge that's created. So on the one hand, you give proprietary control to people who produce knowledge. On the other, we ask them to let people know what that knowledge is, make it freely available. So people have to have access to that knowledge. So coming back to that fundamental point, that IP system is an important component as a policy option. And then I talked about IP enabling. By providing control over your output, you're able to deal with it. Because if you did not have control over what you produce, you are not able to deal with it. And dealing with it means you are able to interact with third parties who might want to take that knowledge to another level in order to make it acceptable as a product or a service. So by virtue of IP, you're able to now have a proprietary right. So you have kind of artificially created something tangible out of something intangible. You have created a right that you can now sell, you can license, you can donate, you can do things with it, which you would not otherwise have been able to do if you did not have rights over that piece of knowledge. And this allows third parties to invest in and get involved in that knowledge and take it up to another stage in development. So it is a necessary component in order to move research from the research base to the industrial base. Because if it was not available, the industrial base will not invest in taking something, moving up the chain. So on the other hand, if you did not have an IP system, all knowledge would be public goods, freely available for all to use, which is probably utopian on the one hand, but then people will not produce, and there will not be any investment in moving it up the chain. So there has to be some balance in terms of controlling that. And then lastly, IP adds value. What we mean by adding value is once a product comes into the marketplace, IP enables that product to be differentiated. So you're able to differentiate one product from that of another by virtue of IP, by using brands, by using designs, by communicating to the public what a particular product is, you're able to differentiate that from another product. And that enables IP holders to add value to products and to compete in the marketplace. So these are the different ways in which the IP system helps in the innovation process. So having given you that background, what is an IP strategy? When we talk about an IP strategy, we are talking about a set of policy measures designed to facilitate the creation, the protection, the exploitation, what I talked about earlier. You want to promote the creation, the protection, and its exploitation in a way that would serve the national objectives. So you have certain objectives, and you want to create a system that would promote those objectives by the creation, protection, and exploitation of IP rights. So it allows for a more structured and planned approach for government to think in terms of how to use the IP system, rather than just having an IP system for the sake of having a system or because it's required by international regulations. That is one lower level objective, but the higher level objective is how do you make this work for the benefit of the country? How do you make this actually operationalize to producing something that is useful for the economy? And that is, on the one hand, useful for governments to think in those terms. And for us in WIPO, it's important because a large part of our work is interacting with countries in terms of implementing using the IP system for their economic benefit. And how do we do that? If we have a more structured, planned approach, it helps us also. So it is something that is useful for both sides. So in designing an IP strategy, the first thing one has to determine is what do you want to achieve by this? What are the objectives that a country might have? So of course, fundamentally, your objective is to improve economic performance. But what specifically are we talking about when we talk about improving economic performance? So different countries have different objectives. Of course, you would say you want all of the above, but it's perhaps better to have some specific goals. So you would want to promote exports. I mean, Estonia, for example, is a small country. You have to be able to export in order to grow economically. You want to attract investment. You want to promote local industry, which might, in some countries, particularly in developing countries, but in many countries, to exploit the cultural and other products that are unique to the country. You want to strengthen domestic creativity, adapt foreign technology to your local needs, strengthen enforcement, and conform to multilateral and bilateral obligations. Now, this is something that in many countries in this region, because of EU conditions, countries are required to do certain things, improve national IP coordination, and protect traditional knowledge and traditional cultural expressions. These are some of the objectives that might be there for countries when they're deciding where do they want to go. So in designing an IP strategy, the first thing one needs to figure out is what do we want to achieve? Where do we want to go? And that should be something in the medium to the long term. Where does one see oneself in the near to the long-term future? Having determined where you want to go, one has to determine where you are now. So what is the present context of the country? And that is, you need to do a detailed assessment and audit to understand the status of the country from an IP perspective as to where they are now. You have to see what is the economic context of the country, what is its legal framework. We saw some of it this morning. What is the administrative framework? Who does what, basically, IP enforcement. And most importantly, for an innovation system, who are the actors that are relevant for the IP system to work? Of course, you have government, but you also have the entrepreneurs, the small and medium-sized enterprises. You have the universities and public research organizations, the traditional knowledge and traditional cultural expression holders, inventors, creators, and the various intermediaries that assist this process. These are the more important stakeholders that are relevant in determining how an IP system functions in a country. And in doing an audit or an assessment of a country, one has to literally determine first identify who are these people in a country, map them all, and then determine what is everybody doing, to what extent is IP useful for them, are they using IP, what are their challenges, what are their problems, what are the gaps, and what are their needs, and what has to understand the whole context in terms of where the country is at present and how they want to get to where they want to get to. And some of the challenges you might come up, which we have come up in doing these kinds of exercises in countries, are some of these things. No local innovation, more imitation. I don't think this applies to Estonia because you're considered a very innovative country. But then when I was coming in the plane, I saw an article about Estonia being one of the primary startup countries in the world. And in that article, there was no mention of intellectual property at all. So that indicates that IP is not in the thinking in terms of, it is a great startup nation, but where is the IP and to what extent is IP managed effectively in Estonia? It is interesting to see. Perhaps you're managing very well without IP, I don't know. But this is something I observed in reading this article. Then a common problem in many countries is the lack of linkages between research and industry. And this is absolutely crucial for any innovation system to function. And if this is not functioning, then it's not going to work. The IP office is not engaged in the innovation system, meaning the IP office is basically, like in many countries, simply granting rights. And then granting rights, and then there is no further, how do you exploit those rights? They're not involved in that process. And now IP offices are changing and thinking about being more customer-oriented and being more practical and proactive in terms of meeting the needs of its customers. Not so much in terms of granting rights, but in exploiting those rights. Then the IP laws are not adapted to the needs. We heard again this morning a lot of discussion about the situation in Estonia, and that is not meeting some of the needs of the stakeholders here. So this is an interesting and important question to ask. Are the IP laws adapted to the needs of the country? Then, of course, there is a lack of awareness by the various stakeholders of what IP is, how do you manage IP, how do you exploit IP, how do you make it useful for your work. And many people see the IP system as too complex. And I agree, it is very complex. But it doesn't need to be, because it could be, you could just know the IP system insofar as it affects your needs. You don't need to know the whole of the IP system. And then benefits are always long-term. You don't really see the benefits immediately. And the cost of the IP system is, again, a barrier. It's an important barrier for small and medium-sized enterprises who can't bear the cost of filing applications, particularly filing international applications. And the IP support services, which means all of the different technical knowledge, expertise, understanding of the system is weak in a country, so there is no possibility to support those who are actually producing and generating IP. So these are some of the challenges we have seen in conducting some of these assessments, and some of them might apply to you, some of them might not, but these are some of the challenges that come up. So how do you get there? Having identified the context, having identified the challenges, and having identified where you want to go, I have kind of put 6 broad headings as to where, what you need to do in order to get to where you want to go. And the first thing you need to do is you need to have an IP legal framework which is compliant with international obligations, but also meeting national needs and priorities. So that is something that has to be looked into, and to see whether how do you make the national context, legal context, applicable to the local needs. And the IP administration must not only dispose of IP applications efficiently, but must also facilitate the use of the IP information and participate in making the IP system relevant for the national good. The third thing is IP generators and users. They must understand the IP system, know how to access and exploit IP rights, and know how to manage their IP assets. That's, again, developing skills of the IP generator users. IP support institutions and service providers also have the skills and knowledge to be able to assist the IP generators and users. And we're talking about chambers of commerce, incubators, science parks. All of these people should have the skills to be able to support the generators and users. IP enforcement must be reliable, efficient, and predictable. And 6, IP is a cross-cutting issue. IP goes across all of the different areas, subject areas, whether we talk about health, education, science, environment, technology. In all of the different areas, it impacts. So therefore, all of the other policies must take into account the IP element. So every policy that comes out has to have an IP element also integrated into it, otherwise there will be a mismatch. So it's important that all of the other policies have this IP element integrated. So if you have all of these 6 elements in place, hopefully you would have then a more effective IP system, which would then strengthen the conditions for the creation and development of new and improved goods and services, which would facilitate job creation and increase welfare and contribute to economic development. That is the ideal scenario of how things would be in an ideal IP strategy development process. What is the methodology? There is no rocket science in this. This is something I think everybody who's doing this kind of activity would engage in. But we in WIPO, we basically think in terms of doing a desk review, which is going through all the published documents, policy papers, etc. of a country to understand the status of that country. And then having identified the relevant people, you would have face-to-face interviews, in-depth interviews with people to really understand what is said, is it actually happening on the ground? Because you have wonderful policy papers in countries, but when you actually talk to people, they say, what policy, which, where, we never heard of it. It doesn't apply to us, or whatever. So you have, when you talk to people individually face-to-face, you understand what is the ground reality, as opposed to what is aspirational. And that ground reality is what is relevant to understand, and you understand that by talking to people directly. And then it's a process of understanding what the issues are, what people are facing, and what they think should be done to make the situation better. And that is an intelligence gathering exercise that is the basis for creating an IP strategy. And then on that basis, you create a document, an outline, and an implementation plan as to how you want to move on with an IP strategy. So this is how I see the main elements of an IP strategy document. You would have the basic background, the IP context, and then identification of the issues and challenges as has been extracted from the various stakeholders. And then how do you get to those outcomes that you want to? You have identified certain outcomes, how do you get to them? And then you develop an implementation plan. You have to have a coordination mechanism. You got to have a champion in a country, somebody who really moves it. If there's no one who is committed at a high level to move this kind of exercise, it will not happen. You have to identify partners, identify funding, identify the indicators, timelines, etc. All of these things have to be thought through and put together. This is broadly what an implementation plan would look like. You would have an outcome that you want to achieve, and then you would have the various activities that you would do to get to that outcome. You would identify the resources and the risks, and what kind of indicators would let you know that you're on the right track and that you're actually meeting your goal. Now, how can WIPO help? This is something that we are ready to help and are doing this kind of work with different countries. We provide what is called IP strategy development support, which is, well, I am here providing IP strategy development support. This is part of that kind of program. But what is essential to be understood is that it is something that must come from the country. It is something that is requested from the country. The country has to take it through. It is not WIPO taking it through. WIPO will just support that process, but the country has to want to do it and has to be committed to do it and has to have the people to do it and has to take it through the process. We can support in terms of providing that guidance by coming and doing that initial assessment, talking to stakeholders, drawing up a framework. We can support in that kind of way. But finally, in actually taking it through, we need people on the ground here to be able to do it. And once a strategy is developed, the actual implementation of a strategy is basically all what WIPO does. We are 1,000 people in this organization, and all our work is pertaining to providing support well, not all our work, but a lot of our work is providing support to countries. So if the strategy would have a component for the legal framework, we have support for that. We have specialists, lawyers, etc., who provide support with that. About the administrative framework, we have a program for modernization of IP officers, and we have support for that. Supporting generators and users, that is who providing skills, education, knowledge, all these kinds of activities, specialized activities for SMEs, for technology transfer organizations, for universities, etc. We have programs that are designed to help in that. So in terms of implementation support, we are able to provide that support. And then finally, what are the risks in this kind of exercise? The biggest risk is that there is no commitment from the country, so we need to have commitment from the top to be able to carry that through. The objectives can be over-ambitious. There may not be resources, or even if there are resources, there's a competition in a country for funding. There is no project team, there's no focus, like you want to do everything. So it's better to have some identified areas to go into rather than trying to do everything. And resistance to change, people don't want to change. People are comfortable the way they are, and they would rather not, because change is hard. And then stakeholders, there's no buy-in by the stakeholders. Unless you really bring stakeholders in and talk to them and convince them of the necessity of doing something, people are not interested in participating. So it has to be, the stakeholders have to participate in that. So these are the kind of risks that one might face, and why one might not succeed in doing that kind of activity. So this is broadly what I want to say. If there's anything that you would like to ask me at this point or later, I'm happy to do that. Thank you.
Questions, please.
In terms of implementing such a policy, do you have could you elaborate maybe on an actual case or on a particular country where WIPO was active and on a success story?
Success story.
Or yeah, just to have a little bit a feeling of how is it on the empirical level.
Well, it's a very complex process. These things take years to put in place, and we have started working on this a few years ago. There are some strategies that have come out, but probably some of them, the furthest on the scale is those that have actually been adopted by a government and accepted probably as a strategy document by the country. But then the implementation process goes on for about another 5 years. So I don't really have anything that has, from beginning to end, that one can say that we have done. You know, they are still in different stages, and a lot of them are in developing countries.
So Asia is let's say, I mean, is there a feeling that, let's say, in Asia there's a lot of demand for that, or is somehow
a lot of demand from African countries actually?
Okay. Oh, yeah.
Asia, yes, in some countries too, but Asia is also, I mean, African countries are I think more thinking about this now than other countries had already, you know, used the IP system quite effectively in countries like Malaysia, Singapore, India. They are quite sophisticated in using the IP system.
Thank you. It was an interesting presentation, but actually I have a bit broader question, and it's about role of WIPO in today's environment. Because when it comes to WIPOs, then WIPO can help us with different definitions, concepts, explanation, but do you think that WIPO could be a forum where significant changes in IP system could take place, or it could be just discussion about definitions and all these classifications? Could be WIPO a leader in this area?
I hope so. I think your question is implying that WIPO is not able to be that kind of leader. As I said, we have something like over, I think it's 188 member states. So you can imagine when you have 188 countries of different sizes, positions, power bases, etc., who are trying to come to agreement on a particular way of doing things, it's not that easy. And so yes, it is the only forum there is for that. There's no other forum that can really discuss these issues and take something forward. But it's a slow process.
But I understand it's like minimum level, but could it be the case that one day it will be decided in WIPO that maybe like copyright, it will be like 20 years of protection or any other significant issues?
Well, it depends on the member states. We are run by the member states. If the member states so desire, and but for me to say that it will become 20 years when that is one end of the spectrum to the other end of the spectrum, you will have countries who will say absolutely no, and countries who will say absolutely yes. So how do you then come to a point when people agree? I mean, you had to get all these countries to agree.
No, you can't really come to this point, so it will be a lot of discussion.
There's a question.
Yeah.
Back there.
Hi, my name is Trine, and I'm a lawyer, IP lawyer. And my question involves, I mean, IP has been around for centuries, almost a couple of centuries now. So but IP strategy as such is quite a new thing. So I would say that for many years, many decades, the main IP strategy for many countries was imitation, copying, learning from others just by, you know, basically stealing. And now that we have TRIPS since 1995, we have to do it all, the same things, copying, imitation, learning, and so on, in a much more stricter context. And you brought out many of the methods how to do that, but what do you see, what are the main tools, main effective means how to make IP strategy work in the context of TRIPS?
In the context of TRIPS, let me just go back to that slide. I think I hinted at it there at the number 1, compliant with international obligations. This is the reality today. You want to go back and say, okay, before the TRIPS we could do this, that, yes, true. And, but it's not the reality today. The reality today is that you have an international agreement that has been agreed to by X many countries, that is part of international law, and every country who wants to join the World Trading System has to be compliant with the international agreements. So that is your base. Now, beyond that base, there is policy room, there is space, but the space is limited. It's not what it used to be. It is limited. But within that space, there is still options and possibilities to do what you want to do in a country. So given the current context that the international agreements are in place, and IP strategies, as you said, is new to the extent that this has become something far more important today because of the knowledge economy. Those days, you didn't have all these intangible assets that were so important before. Now, 80% of a value of a company is intangible. So, and value is based on that now. So it was not the case before. Earlier, it didn't matter so much. Now it matters. Everything you do matters because IP is now at center stage because the knowledge economy and because the internet. Everything moves much faster. Things are copied much more easily. You don't have the protections you had before, the physical protections. So this is again the reality. I can't put back the clock in time.
Thank you.
Okay, thank you very much. So
Thank you.
for the insight.
Thank you. Thanks.